Human rights of all migrant workers and members of their families. 2. Article 20. 1. No migrant worker or member of his or her family shall be imprisoned merely on the ground of failure to fulfill a contractual obligation. 2. No migrant worker or member of his or her family shall be deprived of his or her authorization of residence or work permit or expelled merely on the ground of failure to fulfill an obligation arising out of a work contract unless fulfillment of that obligation constitutes a condition for such authorization or permit. Article 21. It shall be unlawful for anyone, other than a public official duly authorized by law, to confiscate, destroy or attempt to destroy identity documents, documents authorizing entry to or stay, residence or establishment in the national territory or work permits. No authorized confiscation of such documents shall take place without delivery of a detailed receipt. In no case shall it be permitted to destroy the passport or equivalent document of a migrant worker or a member of his or her family. Article 22. 1. Migrant workers and members of their families shall not be subject to measures of collective expulsion. Each case of expulsion shall be examined and decided individually. 2. Migrant workers and members of their families may be expelled from the territory of a state party only in pursuance of a decision taken by the competent authority in accordance with law. 3. The decision shall be communicated to them in a language they understand. Upon their request, where not otherwise mandatory, the decision shall be communicated to them in writing and, save in exceptional circumstances on account of national security, the reasons for the decision likewise stated. The persons concerned shall be informed of these rights before or at the latest at the time the decision is rendered. 4. Except where a final decision is pronounced by a judicial authority, the person concerned shall have the right to submit the reason he or she should not be expelled and to have his or her case reviewed by the competent authority, unless compelling reasons of national security require otherwise. Pending such review, the person concerned shall have the right to seek a stay of the decision of expulsion. 5. If a decision of expulsion that has already been executed is subsequently annulled, the person concerned shall have the right to seek compensation according to law, and the earlier decision shall not be used to prevent him or her from re-entering the state concerned. 6. In case of expulsion, the person concerned shall have a reasonable opportunity before or after departure to settle any claims for wages and other entitlements due to him or her and any pending liabilities. 7. Without prejudice to the execution of a decision of expulsion, a migrant worker or a member of his or her family who is subject to such a decision may seek entry into a state other than his or her state of origin. 8. In case of expulsion of a migrant worker or a member of his or her family, the costs of expulsion shall not be borne by him or her. The person concerned may be required to pay his or her own travel costs. 9. Expulsion from the state of employment shall not in itself prejudice any rights of a migrant worker or a member of his or her family acquired in accordance with the law of that state, including the right to receive wages and other entitlements due to him or her. Article 23. Migrant workers and members of their families shall have the right to have recourse to the protection and assistance of the consular or diplomatic authorities of their state of origin or of a state representing the interests of that state whenever the rights recognized in the present convention are impaired. In particular, in case of expulsion, the person concerned shall be informed of this right without delay, and the authorities of the expelling state shall facilitate the exercise of such right. Article 24. Every migrant worker and every member of his or her family shall have the right to recognition everywhere as a person before the law. Article 25. 1. Migrant workers shall enjoy treatment not less favorable than that which applies to nationals of the state of employment in respect of remuneration and a. Other conditions of work, that is to say, overtime, hours of work, weekly rest, holidays with pay, safety, health, termination of the employment relationship and any other conditions of work which, according to national law and practice, are covered by this term. B. other terms of employment, that is to say, minimum age of employment, restriction on home work and any other matters which, according to national law and practice, are considered a term of employment. 2. It shall not be lawful to derogate in private contracts of employment from the principle of equality of treatment referred to in paragraph 1 of the present article. 3. States parties shall take all appropriate measures to ensure that migrant workers are not deprived of any rights derived from this principle by reason of any irregularity in their stay or employment. In particular, employers shall not be relieved of any legal or contractual obligations, nor shall their obligations be limited in any manner by reason of such irregularity. Article 26. 1. States parties recognize the right of migrant workers and members of their families a. to take part in meetings and activities of trade unions and of any other associations established in accordance with law, with a view to protecting their economic, social, cultural and other interests, subject only to the rules of the organization concerned. b. To join freely any trade union and any such association as aforesaid, subject only to the rules of the organization concerned. c. To seek the aid and assistance of any trade union and of any such association as aforesaid. 2. No restrictions may be placed on the exercise of these rights other than those that are prescribed by law and which are necessary in a democratic society in the interests of national security, public order, order public, or the protection of the rights and freedoms of others. Article 27. 1. With respect to social security, migrant workers and members of their families shall enjoy in the state of employment the same treatment granted to nationals in so far as they fulfill the requirements provided for by the applicable legislation of that state and the applicable bilateral and multilateral treaties. The competent authorities of the state of origin and the state of employment can at any time establish the necessary arrangements to determine the modalities of application of this norm. 2. Where the applicable legislation does not allow migrant workers and members of their families a benefit, the states concerned shall examine the possibility of reimbursing interested persons the amount of contributions made by them with respect to that benefit on the basis of the treatment granted to nationals who are in similar circumstances. Article 28. Migrant workers and members of their families shall have the right to receive any medical care that is urgently required for the preservation of their life or the avoidance of irreparable harm to their health on the basis of equality of treatment with nationals of the state concerned. Such emergency medical care shall not be refused them by reason of any irregularity with regard to stay or employment. Article 29. Each child of a migrant worker shall have the right to a name, to registration of birth and to a nationality. Article 30. Each child of a migrant worker shall have the basic right of access to education on the basis of equality of treatment with nationals of the state concerned. Access to public preschool educational institutions or schools shall not be refused or limited by reason of the irregular situation with respect to stay or employment of either parent or by reason of the irregularity of the child's stay in the state of employment. Article 31. 1. States parties shall ensure respect for the cultural identity of migrant workers and members of their families and shall not prevent them from maintaining their cultural links with their state of origin. 2. States parties may take appropriate measures to assist and encourage efforts in this respect. Article 32. Upon the termination of their stay in the state of employment, migrant workers and members of their families shall have the right to transfer their earnings and savings and, in accordance with the applicable legislation of the states concerned, their personal effects and belongings.